This is another interesting case I got involved in, so we're going to go through this. Bob prepares a handwritten will in 1986, leaving everything to his girlfriend Jane. They are together but living separately for 20 years, and then he moves to another state. They stay friends, but he never tells her she is his heir. At his death, his distant relatives file a probate action challenging the validity of the will. How could this situation have been avoided?
Well, first and foremost, as you guys know, don't let your estate go through probate, right? Should have had a trust, everything would have been administered privately, wouldn't have to go through that process. Secondly is, although the state of Oklahoma does allow or acknowledge certain types of handwritten wills, they have to follow very specific guidelines, just like the wills that we prepare, handwritten, signed, dated, things like that. We generally discourage those for us and anyone else because they just don't address all the situations that might arise with respect to your state should something happen to you. This is not something you really want to take on yourself. But then finally, again, we're kind of back to the issue of communication, letting somebody else know what is expected of them or what they can expect should something happen to you. We talk a lot with our clients, including in the portfolio that you have. It says people to contact. There's a lot of location lists, things like that have been mentioned. So hopefully your successor trustee, your children, whomever, know kind of where to get started. First and foremost, they call us, obviously, for their free consultation if something happens to you. But sometimes letting them know, in this case, had Bob let Jane know, if anything happens to me, I've got a will over here, here's what you need to do in the event that happens. So in this case, communication goes a long way.
I want to interject one thing. You were talking about the holographic wills or handwritten wills in the state of Oklahoma. Another reason, just to kind of try to steer away from them, even if you can write it and get it admitted to probate, you meet all the requirements, you may think you're doing yourself a favor, but you're really not. We just got through with a probate where a wife had prepared her own will, and in it she mentions her husband, and then she also mentions her 2 sons. Well, in fact, she did not have 2 sons. She had 1 son and 1 stepson, but she loved them both. I mean, so her heart was in the right place. She was trying to do the right thing, but it can create a lot of problems. And then, it's harder on people sometimes when you're trying to make it easier and better for them. You wind up hurting them or, getting yourself into a situation that you never would have imagined yourself in. And we did get it all worked out and everything, but we had to go through providing documentation, who this person was, why it said he was a son and he actually was not in fact a son. So just another reason to not try to do things yourself.
And the same logic applies, not necessarily just in a will context, but in a trust. But for most of you that have trust in here, if you choose to amend your trust, make notations on your trust, we get that question all the time. Can I just handwrite some changes? Can I prepare my own? That creates, as you can imagine, all types of problems with respect to interpretation. Same thing to amend or otherwise modify your trust. It still has to follow very specific guidelines. It has to be consistent with the rest of the trust. Otherwise, you could create a lot more problems than you're trying to solve. That's just a common question we get a lot as well.
And in this particular case, this was false economy. When Bob died, his estate was $5.5 million. So he could have afforded to have a trust prepared. But what happened is the relatives tied up the proceedings in court so long, and Jane's health was failing, and she was getting older, and she said, just give them 1/3 of the estate so they'll go away. So she wound up giving them about $1.5 million or more to just send them away, even though they had no legitimate claim at all, so she could get all of her life. And all of that could have been avoided if it had been done correctly. Okay, next case. Jean is 86 with 3 daughters. She appoints the oldest, Susie, as her successor trustee and her agent. The other two, Mary and Beth, decide they don't like Jean's decisions and bring an action to have her declared incompetent, to have the appointment of Susie set aside, and to have themselves appointed to manage her affairs. Susie lives out of state and is not aware of what has happened until she finds large sums missing from Jean's accounts and then has her access cut off. What could have been done to avoid this problem?
Well, this is a little bit similar to the previous case in that, by having everything executed, the will executed with an attorney or the trust, we go through a process for, as you guys know, we visit, we talk through the issues. If there's any indication that competency may be an issue, there are additional procedures that we can apply to satisfy ourselves and your family that everything is proper. There's situations where we might videotape or the execution just to stave off any potential claims that other family members might have, which, as you know, they wait until someone's passed away before they make those claims. So that's something that is really important to use. So a law firm such as ourselves, we try to identify those issues. Going back to the last question, if it was a handwritten will, there's no one there that can attest, no witnesses, no one can attest as to the competency of the person signing the document. So.
Good point. This particular case went to court, and Mom became all flustered. If you can contemplate this, you've got an 86-year-old woman who's being put on the witness stand and attacked by her daughters. Can you foresee her becoming flustered? Well, Mom does. She becomes flustered. The court says, I can't determine whether she's competent or not, so I'm going to appoint a CPA to manage her finances and an attorney to make all of her health care decisions for her while we wait to see whether she's competent or not. Could this have been avoided?
Well, it raises a couple issues. Number one, we have access to experts that could help prepare the mother for that hearing. Rather than go at it blindly and expose her to whatever line of questioning the attorney or the other side may have for her, there's some preparation that can go that we can get involved with that will make that process smoother. The second issue, again, is just trying to maintain the mother's control over her own affairs. So he mentioned they were trying to appoint a CPA and other people involved. Again, back with ensuring that you have valid, durable powers of attorney in place, including advance directive for life decisions. Make sure that those are up to date, those are valid, they're not too remote in age that they're not going to be upheld. That allows, in this case, with the wife's mother, or in your case, to maintain control over who makes your decisions and what type of decisions in the event you're unable to do so.
Well, this particular case has been in a contested guardianship for over 3 years. Susie doesn't think her mom is incompetent, and if she is, Susie should be responsible for managing her affairs for her because that's what her mother wanted. Her two sisters insist Mom is incompetent, and only they should be appointed. No one is willing to compromise. The court has required a battery of tests, and so far the case has already cost Mom's estate approximately $100,000, and it's still ongoing. What could we have done?
Well, in this case, you'd love for the attorneys on both sides or the families on both sides to get together, reach a compromise, hopefully something that minimizes the damage to both sides. But really, this just illustrates just how expensive it can be. Something as seemingly simple as just having an updated power of attorney and related documents that protect you and maintain control of your affairs in the event you became incapacitated or unable to do so. So in this case, the family paid a pretty steep price for that.